You are about to see video from inside the courtroom. You're about to see video from inside the courtroom of our lead prosecutor of 6 counties, State Attorney Larry Basford. His office will argue in front of Judge Kelvin C. Wells in the persecution of Hoot Crawford. They're going to argue that it's okay for a juror, a prospective juror, during jury selection, during jury selection, to make a material false statement in order to get on the jury. You're about to watch this. Now, I had some technical difficulty going on the show, so tell me, please, if everything sounds okay. All right, I need to know if everything sounds okay. And I'm going to check a few settings real quick. I want to make sure. All right, let's see. I'm gonna do that. Make sure we don't get any echo cancellation. Okay, that should be good. I'm gonna look at your comments, see if I sound okay. Sounds okay? All right. Ooh, you're not gonna believe what I'm gonna show you. This is from inside the courtroom. I was in the press box as any journalist can be, and this is what I captured. And you're gonna see 15 minutes of Hoot Crawford's appellate attorney, Michael Ufferman, presenting a motion to interview a juror who made a material false statement to get on the jury during jury selection. All right. Now, there were 6 jurors voted to convict Hoot Crawford after Judge Kelvin C. Wells instructed them to convict Hoot Crawford as long as he left with the 16-year-old girl, because Judge Kelvin C. Wells said that Hoot Crawford, who was representing her as her Marcy's Law attorney, when Sheriff Ford's detectives ambushed them at the Children's Advocacy Center at a voluntary interview. All right. Judge Kelvin Wells said that he wasn't allowed to show that the state never had legal custody of the girl, ever, when he left. Judge Wells said, nope, if they did it, then it's done. That's why there's an appellate attorney. But after the conviction, an investigation showed that 2 or 3 of the jurors made false statements. One of the 6, was a material false statement. And what the appellate attorney is going to argue and win last week with Judge Kelvin C. Wells is that had the defendant known, had Hoot Crawford known, when the question was asked during jury selection, have you or any member of your family been a victim of a crime? This juror said, no, other than some stuff stolen out of my car. No. Well, that wasn't true. This juror witnessed his wife in a domestic violence incident. He was a witness, and it was an ordeal that went on for a long time. Why would the juror say that? So the motion filed after the conviction is to interview the juror, and that is automatic. But not with Judge Kelvin C. Wells, who was huffing and puffing and rubbing his head. There's all kinds of pictures I posted of him, because Kelvin Wells didn't want the juror interviewed. But State Attorney Larry Basford, the top prosecutor of Bay County, Washington County, Calhoun County, Gulf County, Jackson County, and one other one. His prosecutor, he's the lead guy. One of his prosecutors, you're going to see him argue, Your Honor, it's, he says that jury, we have to not interview him. We have to let it go to protect the sanctity of the jury. You're going to see this. You're not going to believe it. All right, let everybody know. I'm going to let a few more people get on here. I'm going to thank a sponsor or two, and then I'm going to show you something that you're not going to believe.
You want to look good? You want to feel good? Little John's Big and Tall is where it's at, right across the street from Sky's Pizza Pie, 5700 North Davis Highway. You can find out more online at littlejohnsbigandtall.com. He's also a member of the iTex trading community, where your iTex dollars are welcome. Don't let back pain and neck pain get you down. Find relief at Brown Chiropractic Center on St. Andrews Boulevard in Panama City. Dr. Sherry Brown helps people heal naturally with chiropractic adjustments and deep tissue massage. Call 769-3777.
All right, so I posted this video. If you want to go back and watch it, it is posted on this page, okay? But I was sitting right here. This is my camera that captured this, and I will do my best to explain to you what is going on. This was a 28-minute or so. I got 28 or so minutes on my camera, 14 of which are here. So it started off with the guy standing up there is Hoot Crawford's appellate attorney. That's Michael Ufferman out of Tallahassee. He's probably the best in the state of Florida, one of the best in the whole country. Hoot Crawford is sitting behind him. You can't see him because Michael Ufferman is standing up. Now, up there on the screen is State Attorney Larry Basford's lead prosecutor on this case. Okay, that is Frank Sullivan. It's Frank Sullivan's job to say, Your Honor, it's a Hail Mary. I mean, they're just trying to overturn the conviction. One short, it's not a big deal. It happens. In fact, he'll argue it happens a lot. But my concern is that we have a state attorney, Larry Basford, who goes around because it's election time. In August, you can vote for Eric Garman and kick Larry Basford to the curb. But you've got Larry Basford, who is arguing that it's not worth calling out a juror who made a material false statement because we have to protect the sanctity of the jury. Here we go. So he has already made his case. Then you had Frank Sullivan made his case. And this is Michael Ufferman saying, look, that case law that he's citing, it doesn't really apply here. And you'll hear, you won't see because I didn't move the camera, but you'll hear Judge Kelvin C. Wells struggling over this. And he says, that sounds like a really strong case they made there. Barry Bat's a strong case. You'll hear this. That's a strong case. And Michael Ufferman said, are you high? Are you too high? He didn't really say that, but I mean, that's not even, what are you talking about? That case law doesn't apply here. This is very simple. If a juror made a false statement on a material point where the defendant would have picked somebody else, we have to interview the juror. All right, I'm going to go ahead and let it play. I'll explain what's going on a little bit throughout.
To your question, Your Honor, I don't know about the Bay County form. Mr. Pumphrey can correct me if I'm wrong, but what happened is
So Judge Wells is already trying to bail him out. Judge Wells said, yeah, but wasn't that just some kind of form where he answered a question like that? I mean, well, it's just a form is all. And appellate attorney Ufferman is saying, no, Your Honor, during jury selection, defense attorney Don Pumphrey, sitting right next to me, he asked this potential juror. And the jurors said, here, listen, but that's what he's talking about. Judge Wells said, well, it's just a form, wasn't it? No, it wasn't, Judge Wells. It was not just a form. It was a direct question from the defense attorney to the prospective juror.
Ms. Peterson listened to the video of the jury selection proceeding, and she says in her report that at a certain point during Mr. Pumphrey's question, he specifically asked, have you or a family member, I'll quote you, has anybody here ever been the victim or had somebody in their family that was the victim of a crime? So it's a question asked by Mr. Pumphrey.
And I had gone back after reviewing the motion and watched the one here myself, and that was the direct quote. That is correct.
That is correct.
So that was asked by Mr. Pumphrey.
It was, Your Honor, yes. So as far as the nephew goes,
Judge Wells was there. You were there, Judge. Yeah, but I was on Facebook.
The defense has failed to meet prong 3 of the De La Rosa test. I will concede that that prong was met by Mr. Pumphrey as far as the issue of Juror Brown's wife's domestic violence case.
Right.
However, the defense fails to really get into the first prong of the materiality prong. Mr. Alperman talked about the materiality prong a little bit there, but he doesn't go far enough. If you look at some of the case law that I cited in my motion, specifically Johnson v. State, 6-3 Southern 3rd, 730, and 4
Hold on,
Supreme Court,
just a second.
2011.
I've switched off his motion and I'm looking at your response.
Yes, Your Honor.
Page
I'm
two.
Page 5 of my response, Your Honor. Yes, Your Honor.
Give me this.
The second paragraph where it starts when it comes to the first prong of the De La Rosa test. And I said Johnson v. State, 63 Southern.
So what's happening here is State Attorney Basford's office is arguing. He's got some case law, some precedent, he says. The problem is it doesn't apply here, and Michael Ufferman's too smart for this goofiness by the State Attorney's office. But Judge Wells is hanging on to it, man. Judge Wells is going to say, that's really, look at this. That's real strong. That's real strong. Watch, this is amazing.
730 Supreme Court, 2011. It goes on to talk about how there's no per se rule of form materiality, that the court can consider several factors, including the remoteness and time of the juror's prior exposure, the character extensiveness of that experience, and the juror's posture in the litigation. When we apply that to the information that the defense is complaining about, you're talking about prior exposure.
Complaining about.
With the juror's wife happened 8 years before. The character extensiveness of the experience. This was a domestic.
Okay, this is, and I'm gonna be quiet. I want you to hear. This is the important part. Here is where State Attorney's office, Larry Basford, says, yeah, the question directly was to the prospective juror, have you or any member of your family been a victim of a crime? And State Attorney Basford's office is going to argue it wasn't an important question. It happened a long time ago, almost 8 years ago. How could anybody remember that? When the juror's wife was a victim of domestic violence and the juror was a witness, and it was a long, drawn-out ordeal. And Basford's office is going to argue, but it was a long time ago. Watch. I'll be quiet. Watch.
Case that with the juror's wife happened 8 years before. The character extensiveness of the experience. This was a domestic battery case, and contrary to what Mr. Hoffman said, this particular case with Mr. Crawford does not involve domestic violence. He was not charged with domestic violence. There were no allegations of domestic violence. And the juror's posture of litigation, he was a witness. He wasn't a defendant. He wasn't a victim. He was just a witness.
Well, I remember the trial. I don't think I agree with you. It wasn't domestic violence. But
That's Judge Wells. I remember the trial. Between Facebook and texting, he has some memory of the trial that happened it was January 30th. I remember the trial. Listen to Judge Wells doing all he can to help the prosecution. Watch.
But wasn't the allegations that there were a brother of the Mr. Crawford's client, the young lady? It was a domestic in that they were brothers and sisters, but not more of a
Listen to him trying, reaching. Oh, what?
a sexual battery.
But
Yeah, would be.
it was, Your Honor,
Could be,
but
maybe.
Mr. Crawford, the case that Mr. Crawford was being tried for did not involve domestic violence. And the contention that the defense would have used a parental restraint in this particular case is disingenuous, because if you remember how the jury selection went.
So now State Attorney Basford's office is arguing that they're lying. If Hoot Crawford had known that the juror made a material false statement, he wouldn't have asked for a different jury. That's disingenuous, Your Honor. And the judge is going to go, yeah, sounds like it.
There were multiple potential jurors that would question the same question, and talked about how they had family members who were going through various issues. And the defense didn't use a single peremptory strike on any of those jurors, regardless of what their answers were and what their experience was, what the family's experiences were with various crimes. And I would also point, Your Honor, to, if I can find the page number to direct you to my response. The bottom of page 6, Your Honor, I want to point out a specific case where the 5th DCA in Summerlin v. State, 260 Southern 3rd, 1181, 5th DCA 2018. In that particular case, the defense asked for a juror interview, and the court would not allow the juror interview. And in that particular case, there was a juror who failed to disclose her own personal experience with sexual assault, and that was in a Luther from City's battery case. The juror's experience was directly related to the charges in that particular case.
Here, State Attorney Basford's office is arguing there have been prospective jurors who have told even bigger lies, and the court was cool with it. I mean, it wasn't, they didn't make a big deal out of it. That's what he's arguing. He's arguing there have been bigger lies told in court, Your Honor. Watch.
And the court still would not allow a juror interview. The nature of the allegations for this juror's wife's charge, or that she was a victim in, is even more attenuated to Mr. Crawford's charges. So I would ask that the court deny the defense motion, because the defense has failed to meet all 3 prongs of the judgment test. This is nothing more than a Hail Mary fishing expedition to
Hail Mary.
the jury's verdict in this case. And
there it is. I told you. That comes around the 5-minute mark. Watch. State Attorney Basford's office argues it's a Hail Mary fishing expedition. It's not a big deal. Told you. Now, the problem is young Frank Sullivan here, he's in way over his head because he's dealing with probably the best appellate attorney in the entire state of Florida. Watch what happens in a moment when Michael Ufferman stands up.
this is nothing more than a Hail Mary fishing expedition to overturn the jury's verdict in this case. And the U.S. Supreme Court and the Florida Supreme Court, as cited in my motion, has been very strict about when jurors can be interviewed and when you can inquire to the nature of discussions in the jury room.
So Wells is looking it over, and Wells is listening to State Attorney Basford's office, and he's going, "Oh man, this is strong case law." And he's about to tell Michael Ufferman, who's standing up, "This is real strong now, Mike." And watch how ridiculous this is.
You want to respond to that last case? That was pretty strong.
Yes, Your Honor.
About the one that had been a victim, didn't disclose that.
Yeah, so Judge Wells is saying, yeah, that he's right. There have been some big lies. It's okay for me to overlook. I don't mind he lied to me. So, but what Ufferman's going to point out is it might be strong if the facts were the same, but that doesn't apply to our case, Your Honor. Watch Wells. You won't be able to see him, but he's rubbing his forehead. He's very stressed out. But watch this. This is the best part.
I'm ready to quote from it, Your Honor. I'm quoting from the case, Sonneman. In this case, the foreperson did not conceal information related to a direct question asked during the voir dire examination. In fact, neither the prosecutor nor defense counsel asked the panel if any of them had personally been sexually assaulted. For this reason, the trial court correctly denied the motion to interview the juror. Those aren't the facts of this case.
Nope.
That is very different than have you or a family member ever been the victim of a crime.
So the question is, why did state attorneys, Larry Basford, why is the top prosecutor for us, who is hell-bent on throwing, hell-bent on destroying Marcy's Law, scaring the hell out of attorneys to ever represent their clients because they might get arrested, just like is happening, elsewhere in the country. Why is Larry Basford doing this? Why is he bringing up case law that doesn't even apply here? Are they dumb? They're not dumb. They're not dumb. They're dishonest. But young Sullivan there, he knows it doesn't apply here. Talk about a Hail Mary.
And, I come back to this, it's clear cut from the Westgate case that I gave you, Your Honor. Materiality means the omission of the information prevented defense counsel from making an informed judgment that likely would have led to a peremptory challenge.
Think about this. Michael Ufferman has to tell the judge what material means. I mean, this is so pathetic. Judge Wells, man.
They would have known, Mr. Crawford being an attorney himself and Mr. Pumphrey being one of the most experienced criminal defense lawyers that I've ever worked with, that they would have known this Juror Brown was a victim, was a witness to and had a wife who was the victim of a domestic situation, when in this case, there's no other way from a loose, general broad standpoint. The underlying incident, all the sexual activity between siblings is clearly a domestic situation. If they would have known that, they would have used a peremptory. Doesn't have to be a cause challenge, but they would have said that juror is just simply not the right fit for this case. We need to explore this further. We need to see why Juror Brown didn't, maybe it's a different Juror Brown. Maybe Ms. Peterson has it wrong. We need to get to the bottom of that. But if it can be established through the interview that Juror Brown did in fact conceal this for whatever reason, intentionally or not, then the next question in the argument is, was Mr. Crawford denied a fair trial because they were denied the opportunity to make an informed judgment about that juror? And again, the James case couldn't be more clear. The question for the court right now is, have we made a prima facie showing that this is material and relevant?
This is so obvious and easy. And I'm telling you, I'm watching Judge Wells. This is my camera. I'm watching Judge Wells. You saw the pictures. He's grimacing, huffing and puffing. He's not even on Facebook at all. He is stressed out because, I mean, if he says no and it goes to appeal, even Judge Wells is going to be embarrassed. He had to grant this. This is how hard you have to work to get, evidently, these judges around here to make a ruling that follows the law.
The other two, I think Mr. Sullivan can see we meet. So it's just prong one. But the only question for the jury review is, have we made a prima facie showing? I submit under that very low burden we have.
Mr. Sullivan, they're basically not even.
See, now Judge Wells went from, that's pretty strong, Mike, that's pretty strong, to now that he actually heard the truth. You can hear how deflated Judge Wells is. Judge Wells is going, well, geez, oh, man, it's not even close. I mean, it's not even close, Frank. What am I going to do? I swear to God, listen.
Even arguing the other drawer, and I don't think it's even close. I think you would concede it's just whether or not it's material. I don't see what the prejudice would be to the state to just,
because what he has to decide today is, the motion is the defendant wants the juror interviewed. Why did he make a false statement that was material? Okay. Wells doesn't want to do that, but he's stuck. So now he's saying there's no prejudice to the prosecution. In other words, and besides that, it has to be done. If this, then that. So Wells is stuck. So he's going to try to say, I'm the one who's going to ask all the questions. Watch.
the defendant's not in custody. He's still got all his conditions of his bond. It's a very limited scope. Hold on for just a second. It's going to be a very limited scope.
You hear how he's talking to Ufferman? The interview is going to be very limited. You're only going to ask maybe one damn question. Listen.
Conditions of his bond. It's a very limited scope. Hold on for just a second. It's going to be a very limited scope as to what we have to deal with, Mr. Ufferman. You understand that? It doesn't go all the way back into. It's only going to be on this one incident. Agree?
Yes, Your Honor.
All right, go ahead, Mr. Shelvin. I'll give you the last word.
Your Honor, the question isn't whether it's prejudiced to the state or not. The question is,
See, now this is where State Attorney Larry Basford's office, our prosecutors. This occurs, by the way, at 9 minutes and 25 seconds. 9 minutes and 25 seconds. And I posted this video standalone below this show. You can watch the video standalone on this page. Now you're going to get State Attorney Larry Basford's office argue this. Are we really going to risk hurting the sanctity of the jury? He's going to argue for the sanctity of the jury while also arguing, it's okay to lie.
is this board violating the sanctity of the jurors' deliberations and bringing the juror in? And the first half of my response deals with U.S. Supreme Court case law that deals with why the Florida Supreme Court and U.S. Supreme Court is very strict about allowing these types of inquiries. Sanctity, the juror deliberations, the jury room is a fundamental aspect of our criminal justice system. So I would agree.
So you see what he's doing now? Remember, the material misstatement was made, the material false statement was made at the very beginning in jury selection. And now you have State Attorney's office, Basford's office here with Frank Sullivan. He's arguing about the end of it. He's conflating the beginning and the end. We're not talking about jury deliberation. We're talking about jury selection. Why is he even doing this? Why are they saying this?
The Florida Supreme Court and U.S. Supreme Court is very strict about allowing these types of inquiries. The sanctity, the juror deliberations, the jury room is a fundamental aspect of our criminal justice system. So I would agree that there isn't a whole lot of prejudice to the state, but that's not the issue. That's not why both the U.S. Supreme Court and the Florida Supreme Court don't allow this.
I agree with you. I've been a judge for 22 years. Never granted a motion like this. Now I do have a case up in Walton County. I think Mr. Ufferman's on that case, where another judge granted the motion for the juror interview, but that judge was covering a docket for me. So I've got that one. But this is the first time I've ever granted one. So I'm going to allow it. And with that being said, I'm not going to take up the motion for.
So now what he's got to deal with is and they came in here, Wells and Larry Basford's office, the prosecutors, they came in here ready to say, no, you don't get to interview the juror. But the problem is they run into Michael Ufferman, the appellate attorney, who laid it out like, look, man, this case law, you don't have a choice, Judge. You got to do this or we're going to appeal. So another motion that they were going to take up was a motion to, I think it's to dismiss the conviction based on this. What Wells is going to do properly is say, I can't dismiss the whole thing until we talk to the juror. And then he's going to say, but I'm going to be the one to ask the questions, not you. Since I got to do this, I'm going to ask them. Watch.
New trial. Because there's no sense. I think both the state and the defense concedes that the motion for new trial is based solely on this jury.
Wins or falls based on your ultimate ruling after we have the jury interview.
I mean, we're here for sentencing today. I don't know if y'all want to proceed with that.
Now, the last thing they were supposed to do is sentence Hoot Crawford. And I don't know if you saw, I'll talk about this another day, maybe tomorrow or this week. I don't know if you saw WMBB's headline. First of all, WJHG did not mention anything about the reason for this interview of a juror, because the juror made a false statement during jury deliberation. Nobody has mentioned that in the news, except for the Beacon of Bay County, but not the legacy news. Why won't they mention that? And the headline at WMBB was, Crawford not punished. Crawford avoids punishment. That was their headline. When I saw WJHG and WMBB's news stories and headlines, it felt to me as though the sheriff, Tommy Ford, and State Attorney Larry Basford, and their people under them, but it starts with Ford and Basford. They were so furious about this. They were so angry that they got their friends in the media to lash out at Crawford, a Marcy's Law attorney who they persecuted. This felt to me like Tom Lewis and them were just lashing out in anger, in absolute fury, because this happened. WMBB has such contempt for you. WJHG, WMBB, and the News Herald, they have nothing but contempt for you. I mean, you just look at the election in Panama City Beach. How about that? Stuart Tetimer, landslide victory over Mark Money Mover Sheldon. And all I hear is how voters were misinformed. See, they still don't understand that they can ignore reality, but they can't ignore the consequences of ignoring reality. That's a quote from Ayn Rand. They think that they can put up perceptions of reality, control a narrative, and somehow that's going to be okay. It's not going to be okay, because the people are seeing reality. WMBB and WJHG, what they did in that story was as evil as I've ever seen. Crawford avoids punishment for kidnapping a girl and running over a DCF agent.
I'll let you be heard on that.
The jurisdiction issue is the problem, Your Honor. The pending still, if we get sentenced today, I have to file the notice of appeal, and then we're fighting back and forth with the first PCA about relinquishing jurisdiction. I think it's cleaner, again, because there is no prejudice to say Crawford's not in custody, he's not flight risk in any way. Well, I'll get this scheduled with your schedule ASAP. So I'm happy to work with Mr. Sullivan so we can propose the 2 or 3 questions that the court would ask of Juror Brown. We can do it in chambers, whatever is the best way that'll protect the privacy of Juror Brown. And but then we'll prepare to make an argument based on whatever Juror Brown says in response to the questions.
How about if you do this? How about if you and Mr. Sullivan get together and you come up with questions that you
Listen to how angry Wells is. All right. The motion was for the defense to interview the juror. Why did you make the false statement that was material? Okay. Wells is so pissed. Why don't you do this? Why don't you guys craft some damn questions and I'm going to be the one to ask them? You're not asking them. I'm going to ask them. And nobody's even going to, there ain't no public going to be around. Listen to this guy. Listen to how angry Wells is. Why is Wells angry? You're a judge, dude. You're a judge. What is, man, I pray that people who hold public trust are held accountable by our Maker, and that you and I do all we can while we're here to let everybody know who violates public judge getting angry about something like this. I get prosecutors. We want to win. But a judge, I wonder what's really going on. I wonder what Judge Wells's motivation really is. Why is he this mad?
We can do it in chambers, whatever is the best way that'll protect the privacy of Juror Brown, and but then we'll be prepared to make an argument based on whatever Juror Brown says.
Listen to how mad
How
Wells
about
is.
if you do this? How about if you and Mr. Sullivan get together and you come up with questions that you're gonna ask?
Yes, Your Honor.
If you can't agree,
Listen,
you can submit questions and the court will decide whether or not they will be allowed.
Yes, Your Honor.
And if you need in camera, agree, Mr. Sullivan?
so now what Judge Wells is saying is he wants to do it by Zoom. He wants the juror to be interviewed by Zoom in camera. And Michael Ufferman here is going to go, no, Your Honor. No, we need to do this in person. Watch this.
When you say in camera, so does that mean that we won't be present? It'll be just the
No, I don't mean that. I mean, your client and the state and the defense will be present, but it'll be closed to the public.
Yes, Your Honor. I agree.
And to protect the sanctity of the juror.
Yes.
I mean, he's just copying the. What do you say again, Frank? Protect the sanctity of the jar.
And there would be, there was some scheduling snafus in Walton County, probably because of me. More, I'm not placing any blame on the state of defense out there about getting the prospective juror.
I know how to do that, Your Honor.
You think you know how to do it?
I will submit an order that hopefully you will sign that once we pick a date for the juror to appear, and I will ask the Bay County Sheriff's Office to personally serve the juror with that order.
Do y'all have any problem with the juror being able to appear by Zoom?
I would
I've
rather.
got no objection.
I don't either, and I want to do the least amount to inconvenience the
Zoom.
juror as possible.
I would rather the juror appear in person, Your Honor.
Got to be in person, Judge. Listen to
Didn't care
what?
about Mr. Sullivan appearing today. But
That's different.
He said you didn't have a problem with Mr. Sullivan appearing on Zoom today. Wells actually said you didn't have a problem with Mr. Sullivan appearing on Zoom today. Listen to this, Judge.
The juror appear in person, Your Honor.
you didn't care about Mr. Sullivan appearing today. But
That's different.
I'm not too looks up there on the video. I'm gonna allow that. I'll tell you what I'll do. We'll send it, and if there's any hardships for the juror.
I understand that.
Any problem with that, Mr. Sullivan?
Sorry, Your Honor.
He's pissed. He's upset.
All right. Anything else to come?
We were supposed to deny this, Judge. That was the plan.
No, Your Honor, I will get back to you next week with proposed questions that we've discussed, and we'll work with your day to get a date.
And then what I would like to do is go ahead, since we're coming down to Bay County, no, that one's gonna be in county. Never mind. I was gonna say we would set everything, but we can go ahead and
All right. That's it. That's what happened. You know what I would love to see? And maybe somebody, maybe one of you has the time, energy, ability, authority. Judge Kelvin C. Wells spent a hell of a lot of time on his phone during the jury. Who remembers that? He was on Facebook scrolling, and he was text messaging a whole lot. Here he is. Now, I wonder who he was text messaging. I don't know if the people or let me tell you something. If I was the defendant, if I was Hoot Crawford and convicted by a judge who spent there was a witness, Deputy Drexler, On day one, she spent about 30 minutes on the witness stand. 19 out of 30 minutes, Judge Wells was scrolling Facebook or texting. 19 minutes out of 30. During evidence. If I'm the defendant, I'm going to ask a motion to see who Judge Wells is text messaging and what's being said. Is he text messaging, I don't know, local kingmakers? Who is he text messaging? I would love to see it. Maybe it's just his wife. Maybe it's family. I'll be done here soon and we can go have a bite. Whatever. Even that. During trial. I mean, he was answering objections without even missing a beat scrolling. I'll sustain that. Text messaging. One time, one of the attorneys asked for a sidebar. And when they got close to the thing, Judge Wells put his phone upside down real quick so nobody could see that he was on Facebook. He turned it over real quick. Yeah, I can help you guys. Is it open to public records? I mean, there was a judge, type this in, at the same time, same week, in late January, there was a judge in another state who did the same thing as Judge Wells did. She was obsessed with her phone. She was on her phone. She was text messaging. Those text messages came to light. How did they come to light? Don't you want to know who Judge Wells was texting and what was being said? Who can ask that question? I'm not going to do it. Okay, I've shown everybody, I've shown the world. I'm not going to make the public record request for that. I'm writing an article about the recall order by the local judge. That's probably going to be appealed. I'm trying to write an article to explain that to you. And I'm behind, of course. So, can they be subpoenaed? Who was he texting? I'm not only worried about the juror and his material false statement, I'm also worried about the judge himself. Why in another state did a judge have to resign because she was texting on her phone during a trial? And here, nobody's even asked. Damn. I mean, if I'm FBI, first of all, I would already know the connections. Only if I was FBI, though. Not now. And I'd be looking. Yeah, but Bernie, that could mean that a lot of convictions where Judge Wells presided, man, they might get overturned, and that's kind of messy. Do you hear yourself? If 500 convictions need to be overturned, then so be it. If that's what happened. If only one, if none. But we deserve to know what the hell the judge is doing on his phone the whole time. Am I right or wrong? So if somebody could kindly find out, if I was the defendant, we got to file a motion to see all that stuff. That's the number one thing I would want to know, even before interviewing the juror. All right. Jeez. See, this is why I needed a break. This is why I needed a break. All right, I want to thank those of you who helped me do this.
When your life is on the line, hire the lawyer who lives in our community, works in our community, and worships in our community. I'm Al Saulene, your Panama City Beach lawyer. 850-215-0628.
Just trying to bring you the news that the local news doesn't bring you.
In Panama City Beach, I'm Tom Lewis, News 13, Panhandle Strong.
Thank you to the Unknown Patriot for your support, as always, and to all the sponsors, including you, Those of you who throw a tip in the tip jar and say, Bernie, keep going. Couldn't do it without you. It's called crowdfunding. Little as $5 a month. The best $5 you can spend on the internet. And I know you know that's right. And you can do that at patreon.com/Bernie Thompson. Patreon.com/Bernie Thompson. It's easy. It's anonymous. And you can quit at any time. And for those of you who are patrons, thank you, thank you, thank you. All right, with that, I'm out of here. Got lots more big stuff for you the next time I see you.